Now let's unpack what transpired at the Senzo Meyiwa trial this past week. The High Court in Pretoria found an audio recording of an alleged confession by one of the accused to be inadmissible. The recording of Bongani Ntanzi, one of the 5 men accused of the footballer's 2014 murder in Vosloorus, cannot be used as evidence. Judge Ratha Mokgoatlheng ruled that Ntanzi's right to a fair trial was infringed upon when he was recorded without his knowledge by Magistrate Vivian Cronje. She took down his confession statement in June 2020. To discuss this further, we're joined by criminal attorney Ratha Mokgoatlheng and reporter Maqoba, who's been following these proceedings. And we begin with you this hour, Maqoba. I mean, it's a very interesting story that we've been following, the developments over the last week and the evidence that was put forward in the past week. Tell us a little bit about that, but also this trial within a trial that was spoken about. What exactly does that mean?
Well, let's try just by reminding the viewers what this trial within a trial is all about. So this is essentially trying to find out whether the confessions that were made by some of the accused can be used in the main trial. So there are 2 accused. Accused number 1, Muzi Sibia, as well as accused number 2, Bongani Ntanzi, who both made statements to police just shortly after they were arrested. So what this trial within a trial is trying to find out is whether those confessions that were made can be used as evidence against them. So the crucial part here, of course, is whether or not those confessions were made lawfully or were lawfully obtained, in a sense, which means that were they forced to make these confessions? Did they make these confessions freely and voluntarily? Was it of their own doing or making? So this is what the trial within a trial is trying to find out, and ultimately the decision of the court, if it finds that these confessions were made indeed freely and voluntarily, they can then be made admissible, which means that they will be admitted as evidence in court, which means the state can then now use these confessions as part of the evidence to build its case against the accused. So what we heard this week was evidence from a magistrate who took the stand, and she told this court that, in fact, when she took the confessions from accused number 2, Bongani Ntanzi, this was on the 24th of June in 2020, she had then conducted this pre-interview and filled in a form that is known as a pro forma form, which basically details the rights of the accused, where the accused is asked whether or not he's willing to make the statement, he has a right to silence and so forth. So it's like a checklist that has to be done before that confession is taken down to ensure that there's no coercion of some sort or torture for the accused to be making that particular statement. So she told the court that Ntanzi, at the time when he made this confession, he had indicated that he was more than willing to make the statement. Number 2, he was happy to make that particular statement. When he was asked as to whether there was any assault, he said that there was no assault. She says he was relaxed, he was calm, and he had no markings or any, injuries on him when he came to make that particular confession, which is quite crucial because this is exactly what the court will have to consider, whether these were freely and voluntarily made. So he says he was not assaulted and that he wanted to make this particular statement. Perhaps let's take a listen to what went on in court when Magistrate Cronje was giving a testimony.
Was asked, did the police or any other person assault or threaten you to make the statement? Answer, no, not at all.
Umbuzo olandelayo ke ngama amaphoyisa noma nje noma uyimuphi umuntu ke owakushaya noma owakusabisa ke ukuthi wenze le statement cha naka lutho nje.
Did anyone influence you to make the statement? Answer, no, I decided on my own.
Ingabe ukhona yini umuntu owaba nomthelela ukuthi wena uzokwenza lesi statement lesi cha isinqumo engayithathela mina?
Did anyone encourage you to make the statement? Answer, no.
Khona yini owakugqugquzela ukuthi wenze le statement cha?
Were any promises made to you to persuade you to make the statement? Answer, no.
Ngaba ikhona yini ithembiso ezenziwa kuwena ukuthi ke noma ke ukugqugquzela ukuthi ke wenze statement lesi? Impendulo yathi cha.
Do you expect to derive any benefits from making the statement? Answer, no, not at all.
Now, let's dig deeper on what the outcome of this trial within the trial will mean for the actual trial. Tia, what's at stake here? You've just heard what transpired in court from Manqoba's recollection and, of course, breakdown. But what do we anticipate now will be taking place?
Okay, thank you for having me on the show, and good afternoon to the viewers at home. So what I'm anticipating now is that the state will be now obliged to use the statement which the accused number 2, Bongani, has made, which is already in writing. So now what the prosecutor intended to do was to get this recording admitted, because he's of the opinion that there is information which is on the recording that is not on the statement, which will help his case. So now that the learned magistrate or the learned judge, that being Honorable Judge Mokgoatlheng, has ruled this evidence to be inadmissible, what this entails for the state's case is simply that they are going to have to rely what is on paper, or what the learned magistrate Cronje has actually put on paper. So in a way, we are yet to hear what is this confession which accused number 2 has made in relation to his participation or his undertaking in the said trial. So I think this comes as a blow to the state's case, because they wanted to use certain information which is on that recording. I mean, it's a 3-hour-long recording, and I do not foresee, or I do not think that the learned magistrate had recorded indeed everything on that statement, and this information would have been on the recording. So I think this might be a blow, or this might come as a blow to the state's case, in that there is information that they might have wanted to use on that recording, which they will now not get an opportunity to use.
And I want us to now focus on Magistrate Cronje now. And before I come back to Manqoba, who's in studio with me, Tia, I just want to ask you, is it commonplace for a magistrate to take out or to take down statements from accused persons ahead of court proceedings, or is this something that it was an anomaly to begin with?
You know, if you read Section 217 of the Criminal Procedure Act, it prescribes what would be considered as an admissible confession. One of the requirements is that a confession may be made in front of a magistrate. So it is not abnormal that magistrates be allowed to take statements. But what I found quite abnormal in this circumstance is that the learned magistrate went as far as recording this statement, not only just recording it, but not doing so with the permission or the consent of Mr. Bongani, accused number 2. So it's not abnormal, but it is quite surprising that in this instance, the learned magistrate decided to record what the accused was saying, and now the state all of a sudden wants to use this against the accused. So I have to agree with also the learned judge that it must be considered inadmissible.
Now, Manqoba, there is the magistrate who took down Bongani Ntanzi's statement, who's taking the stand this week. What is set to come out of her?
Well, expecting the cross-examination to continue this week. Remember that Tropua, where we were on Friday, was around the ruling that came out of the court. But perhaps let's take the viewers back to some of the reasons why the defense had opposed this particular application for that recording, audio recording, to be used in court. So they argued that, this is a violation of accused number 2's rights. So this is premised on Section 35(5) of the Constitution that speaks to the obtainment of evidence, and that if evidence is obtained in a manner that is unlawful, that evidence should then be not considered by the court. And it also speaks to the fact that, how this evidence was extracted freely and fairly. So what the defense had argued is that accused number 2, Bongani Ntanzi, was not told at the time when that recording was made that was in fact being recorded. So he did not consent to that recording being made. The state had argued that it's a mere electronic version of the statement that was taken down, which included that pro forma form as well as that confession. But of course the judge saying that, he was also swayed by the arguments that the defense has made. But perhaps let's take a listen to what the defense had argued as far as the rights of accused number 2 are concerned, just to get a full picture of what this argument was all about.
My Lord, I also object to the application brought by the state at this hour. Since, my Lord, yesterday, it was clearly indicated that the state was no longer intending to lead this information. And hence, as a result of that, my Lord, I listened to the recording alone without my client. My client has never listened to this video recording. I have not been given instructions regarding that because I was under the impression that the state was not going to use that information. As a result, my Lord, I will ask again, as I've asked yesterday, that will be given an opportunity, because if the state is allowed to proceed at this moment, my Lord, that will amount to an ambush on the part of accused number 5.
With that, let's just take a listen then to the ruling that was then made by the judge.
If this court allowed such an egregious flouting and flagrant flouting of accused number 2's constitutional rights in terms of section 35(5), it would not be in the interest of justice to do so, because accused number 2 would then be continuously subjected to a trial unfairly.
Now, Tsiye, the court ultimately deciding in the defense's favor that this recording is inadmissible in court. Now, what did the judge use to weigh in on the judgment that he made, and did it have, or rather, is it going to have any significant bearing on the trial, within the trial, as it has been dubbed over the last few days?
Well, I believe that the court correctly ruled that this evidence is inadmissible, taking into consideration that we have to understand that when the magistrate was taking down the statement of accused number 2, Mr. Bongani, she was recording him without his consent. There was no consent that he be recorded. I mean, for example, take, for instance, I just want to emphasize this issue of the importance of consent. If now there's a telemarketing which is happening, whoever who is on the other side of the phone informs you that the telephone is being recorded. So the issue of consent becomes also very important in the case which is before the court, or in the recording of Mr. Bongani's statement. So I think the court correctly so took into account the fact that the recording was done without the consent of accused number 2. Now, what bearing does this have? Look, as I earlier mentioned, the state, I believe there is information which the learned magistrate had left out on the statement, which they are intending indeed to use. Now, this statement or this recording, now that it can't be used, it would entail that it is negatively influencing their case. So that is my opinion in how this would negatively affect the case going forward. However, we still have the trial. The state hasn't closed its case. I believe there's still more evidence to be made, and we will see. And after the ruling of the court, how far can the state go in trying to get this evidence or the statement of accused number 2, which is now on paper, to be admitted.
Yeah, and very briefly on that point, Tsiye, as we wrap up the conversation, do you think that the state might have any aces up their sleeves that they could present over the coming days to help its case in any way?
Well, already let us look at the evidence which is before the court. So I think, if I may, because now I'm not in position of the docket to make such a determination, but I do think with the evidence which the state has already laid, being the cell phone records which are connecting the accused to the crime scene, the the mere fact that the pistol which was used is being linked to one of the accused. I think in going forward, the accused persons which are before the court do have a case to answer to.
Definitely there. And then, Manqoba, of course, you've just told us that Cronje will continue on being cross-examined. But what else can we expect this week? I mean, it's something that we've been watching very closely for a very long time. And many of us are becoming quite concerned that the family and those closely associated may actually not see justice anytime soon.
It is quite a crucial week, Ropua, in a sense. You've just spoken about the family and how long this case has dragged on. It's now going to 9 years, and on Thursday it will be the 26th of October, and this will be 9 years exactly since Senzo Meyiwa was killed. Are we getting anywhere closer to the truth? Well, it's still a long way to go. Yes. The trial is still a long way within a trial, and only after that then would we see the main trial resuming. So how long this will drag on, we're still not sure at this particular point. But what we do know, Ropua, is that this week we're expecting the cross-examination to continue. Lawyer for accused 1 and 2 indicating they might also reopen their cross-examination tomorrow when the case resumes. Then we're expecting lawyers for accused number 3, 4 and 5 to also cross-examine Cronje, but we're also expecting police officers. The police officer who had transported accused number 2, Bongani Ntanzi, to the magistrate is also expected in court, as well as other police officers involved in the other confessions that were taken from accused number 1. You recall that there was a request for them to be recalled that ultimately had then fallen down or over, but what we're expecting is a lawyer for accused number 3, Charles Mnisi, to cross-examine the 2 other witnesses that were before Magistrate Cronje. Remember, was not in court at the time that they testified, so he's been given an opportunity to do so. So we're expecting that to happen all this week. And of course, 9 years since Senzo Meyiwa was killed, a reflection, of course, that is expected, more especially on the side of those that have been following this case, the fans as well as the family.
Absolutely, Manqoba Mkhunu. Thank you very much and good luck this week. No doubt a very emotional time for the family and close friends as they watch those proceedings take place. We've been speaking there to Manqoba Mkhunu, a reporter on the Senzo Meyiwa murder trial, but also criminal attorney Itsiye Mokimane joining us this afternoon on the discussion around the murder trial and, of course, as you've just heard, what's coming up this week.